All right, let's talk about the closely held LLC and special issues there. This is just going to be a review for you because we've already talked about the issues in the closely held corporation, and we've already talked about the issues in the closely held partnership, and the LLC has the same issues, and a lot of the themes and a lot of the default rules are just the same themes and default rules we saw in the closely held corporation and the closely held partnership. It should be no surprise to you that the major special issues of the closely held business and the closely held LLC are the fiduciary duties and the transfer of ownership interest. In this case, we call them membership interests. All right, so the scope of fiduciary duties in the closely held LLC, the same fiduciary duties that we've already seen. Same traditional fiduciary duties of care, loyalty, good faith, the duty not to commit waste, the duty to monitor, etc. Plus, we have a duty, maybe not a fiduciary duty, we're not going to label it fiduciary duty, but a duty of good faith and fair dealing. The members owe a fiduciary duty of good faith and fair dealing to one another. What does this mean? Well, I can use my discretion and control as a member to further my self-interest, but I must exercise that discretion, control in good faith and with fair dealing to my co-members. All right, let's review the default rules for the transfer of ownership interest, and then we'll talk about specifically in the LLC, what are the default rules about the transfer of membership interest. Remember, in the partnership and the corporation, we already discussed the default rules for the transfer of ownership interest. In the partnership, ownership interests are not freely transferable. I cannot transfer my entire ownership interest to a third party unless my co-partners agree to that. Also, in a partnership, as a partner, I can demand to be bought out at any time. I can dissociate myself at will. I can say I no longer want to be a partner, and if I do so, the other partners have an obligation to buy me out at fair market value. Those are the default rules in the partnership. We can change those in the partnership agreement and in our buy-sell provision in our partnership agreement. In the corporation, ownership interests by default are freely transferable. I can transfer my shares to a third party, and that third party will get my control rights as a shareholder and my economic rights. I do not need the permission of the other shareholders to make that transfer. I might want to change that in our buy-sell agreement, but as a default rule, I do not need the permission of my co-shareholders to transfer my shares. A shareholder in a corporation does not have a default rule to demand to be bought out of the corporation. So if I am unhappy about being in this closely held corporation and I want to exit my investment and I say to the corporation, buy me out, other shareholders buy me out, I demand you buy me out, I don't have that right. They have no obligation to buy me out. If I want a buyout right, or if we want our corporation to have certain buyout rights, we have to put that in our buy-sell agreement. What are the rules for the LLC? Well, the LLC, your ownership interests are not freely transferable. In that sense, the LLC is very much like the partnership. If I want to transfer my ownership interest to a third party, I have to get the consent of all my other members. A member in an LLC does not have a right to demand to be bought out. This is at least the approach of the revised Uniform Limited Liability Company Act. Other jurisdictions might have that right. It might be more like the partnership rule. All right, so if we are drafting a buy-sell provision in our LLC operating agreement, what will it look like? Well, it's going to look very much like the buy-sell agreement that we're going to have for a closely held corporation. Our buy-sell provision in our LLC operating agreement is going to deal with 3 Ds and a B. It's going to deal with these issues: the death of a member, the disability of a member, the divorce of a member, the bankruptcy of a member, the employment of a member who wants to exit her investment, or the retirement of a member. Upon these events, how do we want to deal with the members' membership interests? Will she be allowed to transfer them to a third party? Will her heirs be allowed to have them? Will the LLC have a right to buy out the membership interest? Will the other members have a right to buy out the membership interest? Will they be required to do so? Same issues we discussed when we discussed the buy-sell agreement in the closely held corporation, except we have different default rules. So when we're drafting our buy-sell agreement, we have to understand what the default rules are. What is our starting point? So our starting point for the LLC is that a member's control rights are not freely transferable, just like in the partnership, right? Partners' control rights are not freely transferable. A member's control rights are not freely transferable, but a member's economic rights are freely transferable, just like the partnership. A partner's economic rights are freely transferable. A member can dissociate herself at any time. This is very similar to the partnership, where the partner can just say, I no longer want to be a partner. This is withdrawal of will, dissociation at will. A member also has the same right, at least it does under the Revised Uniform Limited Liability Company Act. The difference is that a member, although she has a right to dissociate herself, she has no right to demand a buyout. Remember, the partner, when she dissociates, at will, she can also demand a buyout of her partnership interests at fair market value. However, when a member dissociates at will, she has no right to demand a buyout. We'll talk about this in a little bit more detail a little bit later. And finally, as you are reading your LLC statute, there might be default dissociation rules that are similar to the dissociation rules in a partnership. This is the starting point from where we begin drafting our buy-sell agreement to deal with 3 Ds and a beer. Once again, let's talk about the difference between control rights and economic rights. Your membership interests are not freely transferable, but that's not quite accurate. Let's divide up our membership interest into control rights and economic rights. Our control rights are not freely transferable. What are the control rights of a member? Well, the right to act as a member, the right to manage the business of the LLC, and various voting rights. Those are your control rights. Those are not freely transferable unless I get the consent of my co-members, all of my co-members. What are my economic rights? Well, first, my economic rights are indeed freely transferable. I can transfer those without the consent of my co-members. What are my economic rights? Well, basically my economic rights are my rights to the residual. That is the profits when it's a going concern, and if the LLC is being liquidated, I have liquidation rights. I get what is left over. All right, let's talk about dissociation at will. Remember, the partnership, we'll just make a little contrast. As we talked about, partner, if you're a partner in a partnership, you can dissociate at will. I no longer want to be a partner. As soon as you say that, you are no longer a partner. You are dissociated from the partnership. And as a partner, if I dissociate at will, I have a right to demand that the partnership and or the other partners buy out my partnership interests at fair market value. Those are the default rules of the partnership. We might want to change those in the partnership agreement. What are the default rules for the LLC? Well, it's slightly different. So this is the Revised Uniform Limited Liability Company Act approach. Your jurisdiction might be different, but it's important to understand the approach of the Revised Uniform Limited Liability Company Act. So I can, if I'm a member in an LLC, I can dissociate myself at any time, but I cannot demand a buyout. That leaves me without control rights because I disassociated myself. I am no longer a member. That leaves me without control rights, but it leaves me with the economic rights. This puts me in this kind of limbo where I have just dissociated myself. I have just given up my control rights, but I maintain my economic rights. It doesn't seem like this is a good thing to do, to dissociate yourself and lose your membership rights, but you maintain your economic rights. How do you protect your economic rights? How do you make sure you're getting your residual? How do you make sure you get what you deserve in liquidation, right? If you don't have control, then you're at risk of not being able to assert your economic rights. So it's probably not a good idea in a revised Uniform Limited Liability Company Act jurisdiction to dissociate yourself from the LLC. If you do, you no longer have control rights, but you still have your economic rights. You might be able to transfer those economic rights to a third party, but generally you want to keep your control rights so that you can protect your economic rights.